I have a lot of clients, a lot of executives that I represent and employers that deal with the issue of employment non-competition agreements. New Hampshire has a law set in regards to this. You have to give those non-competition agreements to the employee ahead of time before they accept their employment. You have to actually hand it to them saying that they're going to sign one. If they accept the job isn't enough, they have to do that before they accept the job. So it's very important to get those documents in front of them ahead of time. There's something called a non-solicitation agreement that says when we give you customers, don't take those customers away from us. Those don't fit into the statute, but there's still something important to consider. And also confidentiality agreements and invention agreements. Those are all something that is generally ways to protect the business interests of the employer. For executives thinking about non-competition agreements, it would be a mistake to say that in New Hampshire they're not enforced. They can be enforced, and recently there's rulings on some of the cases that do enforce them. In some circumstances, though, like for a standard salesperson, it is more likely than not that the courts will only enforce them, narrowly construe them to the customers that that person had a relationship with. So if the person was selling software, dental office software, and they never dealt with certain dental offices, they probably will not be excluded from selling dental office software to others in the industry. That's likely. Certainly if you have somebody that's a talent in a radio show or TV show, it's going to be much broader. The non-competition saying you can't work in the industry in this broadcasting area is probably going to be enforced against them. So facts matter in regards to these things. If you're doing a non-compete because you're selling your business, these restrictions don't apply at all. Because if I'm selling my goodwill of the company to you, and I say 5-year non-competition agreement, the court's not going to mess with that. That's the deal we have. But generally, they'll narrowly construe the non-competition or non-solicitation agreements to the legitimate business interests of the employer in the employment non-competes, which includes the goodwill, being my face is in front of the customer, so you need time for the employer to put a new face in front of the customer, or trade secrets, so not taking any confidential things. You're never going to have a judge allow you to steal from the employer. So if you have questions in regards to this, you can contact me at 883-5501 Dan Marr. I've represented both sides of this, and I've drafted these documents as well. Thank you.